Hi, I'm Alex Bast-Boverhoff, Managing Director of Bridgewater Home Care, and on today's episode of Building Bridges, we've got Welland Valley Legal, and we're going to look at different documents like LPAs, wills, probates, and just look at stuff that you may need to know. Thank you for joining me, Christian.
It's nice to be here. Thank you for having me.
No problem at all. So, who are Welland Valley Legal?
So Welland Valley Legal is a firm of solicitors. We're fully SRA regulated and we are in Uppingham. We provide private client services, so that deals with wills, lasting powers of attorney, but also other types of areas such as estate administration and trusts.
Okay, fantastic. And how long have Welland Valley Legal been going?
So we've been running for 3 years now. We're just about to enter into our 4th year. Last year in 2024 we were finalists for the Leicester Law Firm of the Year.
Fantastic.
And so that's something we're very proud of, and we've been working very hard to achieve, always trying to put clients at the front of our operation and make sure that they're looked after first.
No, brilliant. So you said you've been going for a few years now. What started Welland Valley Legal?
So Welland Valley Legal started in 2022 by my business colleague Natalie. I joined the firm in June 2023, and now we have 4 members of staff. So we're a small firm, but it allows us to provide that personal service to our clients.
What was the reasoning behind you and Natalie sort of wanting to go out and set it up?
That's a tough one. I think it was because really, previously in the past, we've worked for bigger companies and high street companies in and around the areas and bigger cities. And really, I think there was a part of us that felt that there's something that we can offer to our clients which is a bit better than what is currently being offered out there.
Yeah.
Being a small practice of solicitors, we're able to offer a personal approach to our clients, so that every time they speak to us on the phone, it's us they're getting.
Of course.
It's not just another person who they've never met before. So it does really offer that personal service. Also, we do try and keep some of the traditional ways in working. So for our clients especially, I feel that with wills and lasting powers of attorney, elderly clients do prefer to see people face to face.
Yeah.
They still like to keep that traditional way of dealing with things because they want to be able to speak to someone and have that personal approach.
Of course. And I think, like you said, it's that personal approach what people look for. You don't want to be feeling like you're going into a call centre and being passed around pillar to post, especially with documents such as wills and lasting power of attorneys, where they're so important. You want to make sure whatever your wishes are known and put down. And if you're dealing with 5 or 6 different people, that may get sort of muddled through the process.
Yeah, absolutely. And we do also offer the modern approach, such as being able to give virtual meetings. But again, clients may be elderly or may feel particularly vulnerable in going into situations such as offices. So
Yeah.
we do also offer the home visits to clients as well.
No, fantastic. So you've said lasting power of attorney a few times. What is that?
Well, a lasting power of attorney is if you no longer have the capability, whether that's physically or mentally, to be able to manage your affairs or make decisions.
Okay.
You can appoint someone who is legally able to deal with those decisions for you. The benefits of having it in a lasting power of attorney is that you get to choose the people who you trust to make those decisions for you. Otherwise, if you don't have one in place, it's quite often someone who you would not necessarily want to be able to manage your affairs could end up making those decisions on your behalf.
Okay, brilliant. And is there just one sort of lasting power of attorney, or is there different ones?
So there's 2 types of lasting powers of attorney. There's one that deals with your property and your finances.
Yeah.
The other type deals with health. So that could be decisions with regards to medical treatment or life-sustaining treatment if you're unable to communicate with a doctor.
I suppose it's quite a daunting thought having to give someone power of your finances or health. So how do a lot of LPAs, lasting power of attorneys, work?
So usually it's something that you would discuss with the family, and it's really important to have that discussion now rather than leaving it till later. Having the ability to prepare a lasting power of attorney means that you can make the decision about who you would like to manage your affairs, and so you can choose the people who you trust to deal with that. Usually that's dealt with by seeing someone like myself. We can discuss the documents with the clients to make sure they feel that they're comfortable with what they're doing, that they understand the knowledge and effect of what they're doing. The documents are registered with the court, and once the documents have been registered, the attorneys can then use those on behalf of the donor if they need help with anything.
Okay, brilliant. So if I've gone and got a lasting power of attorney in place, does that give them the power straight away, or when does that come into effect?
So the document takes approximately 20 weeks to register. Now it has to be registered with the court, and there are court fees involved in doing so. The reason why it takes 20 weeks to register is because the courts are under a lot of pressure to register all of these documents, but also they have to give a notice period, which is a time in which someone can object to the application if they felt that the attorneys weren't of the right sound mind or character.
Okay.
That's again one of the reasons why these documents need to be registered as soon as they've been prepared and signed, and also why lasting powers of attorney should be prepared now rather than leaving it till later, because when you've got a 20-week registration period, during that time, if you leave it too late, it might be too late for the attorneys to be able to make those decisions when they've got to wait for 20 weeks for them to be registered. So having them done now, put it tucked away in your drawer, safe, so that if you do ever need them, you've got them there ready to use.
Okay, fantastic. So you can really get one at any age, but it will only come into effect when it's needed rather than straight away.
Correct, yeah. I mean, once they're registered, they are in effect at that point, but whilst you still have capacity, your attorneys need to have your consent to be able to use the documents.
Okay, fantastic. And what happens if you leave it too late? What happens if you've just been diagnosed with dementia or another illness and then you go looking for it? What are the sort of problems or barriers you may come across?
I mean, in our experience, leaving it too late is quite problematic, not just for the person who has lost capacity, but also for the family. It can be quite distressing.
Yeah.
If you do leave it too late and you don't have the capacity to be able to create a lasting power of attorney, the family members may have to apply to the Court of Protection for what's called deputyship.
Okay.
Now, the deputyship applications don't really apply to health decisions. It's only under extreme circumstances will the court grant those. So it's really just for property and finances. And under a deputyship, it can take between 9 and 12 months to go through the courts. It's very stressful for the family. And during that time, if that person is requiring care or in a care home, there are lots of people demanding payment for things which the family just can't get access to during that time.
Okay, no, fine, that makes sense. And how about wills then? Obviously, a lot of people don't want to think about, the time comes when they do pass. So, but obviously wills are extremely important documents to have in place. When's the best time to sort of think about putting a will?
Now.
Now.
Don't leave it. We don't know what the future holds, and it doesn't matter what age you are, but we do often see a lot of times people will leave things too late, and it's then too late to start planning for the future.
Yeah.
So it's really important to get a will in place as soon as you can. Again, if you don't have capacity, you can't create a will.
Yeah.
And without being able to create a will, it's what's called the intestacy rules. And the intestacy rules are a set of rules prepared by the government which directs what happens to your estate, which may not always be the way in which you would want it to go.
Okay, fantastic. And obviously, like we said about, wills aren't necessarily a document you want to think about or put in place. If you may have, say, an elderly parent which doesn't have a will in place, what would be the best way, or even an LPA, what's the best way to approach them to start that conversation?
I think it's just having that open conversation about them. It's nothing to be shy about or have that chat about. It's going to happen to all of us. So we all have to be brutally honest and open about the fact of what happens, what do I want to happen to my estate if anything happens to me? And without having that conversation, if we do just shy away from it, nothing gets done. And we do often see a lot of that.
Yeah.
People don't like to have the conversation about wills or lasting powers of attorney. But actually, it's not that bad. I think when they come to places like Welland Valley Legal, we have such a friendly team and we make everyone feel very relaxed and at ease. And they come out of these meetings and they say, actually, that wasn't as bad as I thought it was.
Yeah, I can imagine. It's probably one of those documents, and you're probably in that position where people have a preconception of what it's going to be like, that you go into a bit of a dark, dingy office, someone's there sort of telling you to sign away your life.
Yeah, absolutely. I mean, for me, I think it's very much the same as Bridgewater. The value is in the staff,
Yeah.
and our staff are so good and make our clients feel so welcome, and they will go that extra mile to make sure that they're looked after and that they feel comfortable, and that's really what sets us apart from other people.
No, fantastic. And obviously we've sort of touched on wills and lasting power of attorneys, but you also do probate or support in probate. What is probate?
So probate is a process in which someone's estate is administered. Depending on the value or types of assets that people have may depend on whether they need a probate or a grant of probate. So probate is a legal document, a court sealed document,
Yeah.
which allows the executors or the personal representatives to be able to administer the estate of a deceased person.
Okay, and if you have a will in place, do you still need probate, or what is the process of all of that? Because surely if you've got a will in place, you've already determined what you want to happen to your estate.
Yes, yeah. I mean, that's one of those misconceptions, isn't it, where people think that, well, if I've got a will, I don't need probate. But actually, you still need probate,
Okay.
even if you have a will in place, especially if you have property or cash assets over a certain amount of money. They're quite valuable assets. So
Yeah.
regardless of whether you've got a will in place, the purpose of probate is to establish that it is, in fact, the true and original last will of that person. And it then gives the executors the legal authority to be able to administer those assets.
And why should someone come to yourselves or someone professional to put a will in place? Can I not just make my own will and sign it?
Yeah, I mean, absolutely. Wills aren't wills are documents which anyone can create, but in doing so, you're also open to be able to mistakes.
Yeah.
A bit like I wouldn't do my own tax return.
Yeah.
I would strongly recommend that someone who does want a will goes to see someone who knows what they're doing, who is fully insured, fully trained to do it, and fully regulated. We've often seen homemade wills which have actually been invalid.
Okay.
And the effects of that means that the people who they intended to benefit did not benefit at all. So the importance of having someone who is qualified to be able to prepare a will, I think is actually quite crucial.
Yeah. So in that instance where someone's created their own will and it's invalid, what then happens to that person's estate or money or in general?
Well, if it's an invalid will, the intestacy rules, like we mentioned earlier, takes effect. So the non-contentious probate rule sets out a list of people categorised as to who is the first in line to be able to A, administer the estate, and B, receive the estate.
Yeah.
So it usually goes up to parents, then it'll go to siblings and nieces, nephews, etc., if there are no children of the deceased.
We spoke earlier about lasting power of attorneys and putting people in place that you trust. So how many people do you normally sort of assign to a power of attorney?
Well, the document allows for 4 attorneys to be in place.
Yeah.
You can have more. However, it's probably not recommended to have more. I think the more people that you have, the more chance there is for the document to be misconstrued, or for there to be arguments between attorneys in terms of what they think is the best interest of that person. But typically speaking, it's at least advisable to have 2 people on there, just in case one of the attorneys is away on holiday or can't act due to health. Then you've always got a second attorney who can also act just in case.
Of course. So if you did have 4 attorneys, for instance, What happens if 3 of them agreed and 1 didn't agree with the decision being made?
All the attorneys need to act unanimously, and
Okay.
it has to be in the best interest of the donor. It also depends on how the appointment has been made, because there's different ways in which attorneys can be appointed.
Yeah.
Attorneys can be appointed jointly, which means that they all need to act unanimously in terms of the decisions they make. It also means that if there's a cheque being signed, for example, that all the attorneys have to sign the cheques.
Okay, fine.
The other option is, which is the recommended option, is jointly and severally,
Yeah.
which means that the attorneys still must act unanimously and agree on their decisions. But if one attorney, say for example their children, and one attorney lives in Market Harborough and the other lives in Scotland, it's typically going to be that the person in Market Harborough is making the usual decisions and signing checks and going to the bank, which means that they can do that by themselves at the same time.
Okay, rather than waiting for the person in Scotland who's further away to try and sign everything off, and it just delays the process and makes things a bit more difficult, should we say.
Absolutely, that's it. And jointly and severally also means that if one of the attorneys does unfortunately die or not have capacity themselves, the document is still valid. Whereas with the joint decisions, if one attorney can't make a decision due to incapacity or death, the document fails in its entirety.
Okay, that's interesting. So what would happen if you were later in life, for instance, so you had your husband as one of your attorneys and he was actually in ill health, and you also had your son on it? Therefore, your husband couldn't make a decision, but your son could. Would that mean that your son wouldn't be able to make anything?
If they were appointed jointly, then no, the document would fail. However, if it's joint and several, then yes, the son can still continue to act and make those decisions. Okay,
and what would happen if they were jointly? How do you then rectify that to allow the son to start making the decisions?
You can't really. That's and this is where you need to get the right advice when it comes to preparing the documents. To make people aware of these potential pitfalls in having attorneys acting in certain ways. Now, if the document fails, then the only way to then be able to manage that person's finances is by applying to the court for the deputyship.
And then that's like not having one in place in the first.
Absolutely. And one of the difference between lasting powers of attorney and deputyship is lasting powers of attorney, once it's in place for that person's lifetime. And your attorneys can use that document as if it's their finances, obviously acting on behalf of the donor, but in their best interest, so they can just pop to the bank if they need to. Whereas with the deputyship, you have to pay for a bond every year, which is like an insurance. You have to submit accounts every year to the court to make sure that they can see exactly what's come in and gone out of their donor's bank, so they can see exactly what's being spent. And generally speaking, it's quite an onerous task in trying to deal with all of those things under a deputyship.
Yeah, and you said obviously once the lasting power of attorney is in place, it lasts for a lifetime. What happens if you find through your life one of your attorneys has fallen in ill health? How can they come back to yourself and say we need to update the LPA to remove that attorney because they're no longer, capable?
Absolutely. Yeah, so attorneys can be removed, whether that's due to retirement or health, but you can't update the documents to put a new attorney on.
Okay.
So you can remove attorneys, but you can't add more.
Fine.
So when you do prepare these documents, you've got to be really certain that the people who you're appointing are going to be the people that you want to be able to act, and ensure also that if, for example, you're just appointing one attorney, that you've got replacements involved just in case that person can't act.
So we spoke about lasting power of attorneys are in place from the point that they're done for a lifetime. Is that the same as wills?
I think the importance with wills is that they always need to be reviewed.
Okay.
So it doesn't matter if you prepared a will 2 years ago or 15 or 20 years ago, it's always really important to review them to make sure that they're kept up to date. not only may certain changes happen throughout your lifetime, but the law might change as well. So inheritance tax allowances, agricultural or business allowances might change. Executors or beneficiaries in your wills might have died. But also there's this common misconception that wills are just for elderly people or people with money,
Yeah.
which of course isn't true, because we could have a young couple who may not have a lot in terms of assets, but they might have young children.
Yeah.
And the relevance here is that with a simple will in place, they can appoint guardians who they trust, who can be legal, have that legal responsibility for their children until the children turn 18. Without a will in place appointing legal guardians, the local authority could potentially determine what happens to your child.
Yeah, which is really interesting you say that, because a lot of people assume I'm married with children, therefore if something happens to me, everything would go to my husband and wife and ultimately then supported by my children.
Yeah, that's it. It's a good point, and it's another common misconception that just because I'm married, everything's going to pass automatically to my spouse. But again, without a will in place, the intestacy rules take effect.
Okay.
Now, yes, in most cases, it may be that assets will automatically pass if they're jointly held, but if assets aren't jointly held, the spouse only receives the first £322,000. The remainder of the estate is then split into half. Half is on trust for the children, the other half to the surviving spouse.
Okay.
So it gets quite complicated. It could also mean that inheritance tax may potentially be payable as a result of it.
Yeah, which is really interesting. And I think a lot of people, again, I'm guilty of this, don't consider what happens if something happened to both of you. What would happen to the children? Where would everything go? You just think, worst case scenario, something happens to me, my spouse will get it all, therefore I don't need to worry about it.
Yeah, that's it. And, you know, without a will in place, you don't have that control over who administers your estate,
Yeah.
who looks after the children, but also B, who looks after that estate on behalf of the children until they turn 18. So having someone responsible who you trust, who can ensure that those assets are looked after and invested, or they've seek financial advice or professional advice, so that by the time the children do turn 18, they've got this healthy pot of money that can give them the best start in life, rather than it being spent whilst they're alive.
What would happen in terms of businesses per se? Say you obviously jointly owned a business with your partner, as in your business partner, and something happened to you with half of the business that you own go to your spouse, or what happens to that 50% of the business?
Well, that starts to get quite complicated. It depends on what type of business it is.
Yeah.
How the business is held between the business partner. Is it a limited company? Is it a partnership?
Yeah.
Is there articles of association in place? Is there a shareholders agreement in place? And again, the will can determine what happens to the shares of that company.
Yeah.
But also, this is where from April 2026, the local Labour are making certain changes, which is currently still under consultation. But it means that there's a big change in the way in which you can pass company shares, in particular the value of these, which will pass inheritance tax free.
Okay.
So whereas previously it always comes back to reviewing your will. Previously you may have had a will in place which was suitable at the time. Now it may be that it's not effective, or as effective as you want it to be.
Yeah.
So reviewing the will, especially if you have shares in a business, is really important now.
Yeah. So, you know, like we said about lasting power of attorneys, you can remove but you can't add, but it sounds like wills are a bit more flexible through the lifetime. They evolve, they change, and you're able to adapt your will to where your life is at that point in time.
Yeah, definitely. And as long as you've got capacity, you can change your will as much as you want.
Yeah.
But you never know what's around the corner. You don't know how long it's going to be. So really making sure that you don't leave something leave it till it's too late. So do it now whilst you can, rather than leaving it till tomorrow, which you don't know what's going to happen.
Yeah, of course. No, thank you for all of that. It's been really interesting. So in terms of Welland Valley Legal, what are your aspirations for the business between you and Natalie?
We're just enjoying what we're doing at the moment. We've just moved into the new office in Uppingham, so we're really excited to be part of the community there. Having said that, we do still have a lot of clients and in Market Harbour and the surrounding areas around here. So we just enjoy what we're doing. We enjoy helping the clients, and so for us, that's what it's all about.
Yeah.
We're not looking to grow too big, because we always want to be able to provide that personal service to the clients. So it's nice to have a big team around you, but actually it's more important that that team is manageable and they all have the same ethos as yourself. So whenever someone steps into our office, they'll always be greeted by a smile and a warm welcome.
Yeah.
And whenever someone wants to speak to their lawyer, they're always going to get us. They know who they're dealing with. So for us, it's more important about being able to provide a good service to our clients.
It's about providing that quality over the quantity.
Definitely. Yeah, of course. Yeah, and it's the same with yourselves. You know, a lot of clients that we see, it's very personal what we're dealing with.
Yeah.
So they want to make sure that the people they're seeing care about what their needs are.
Yeah.
And satisfying what their needs are in terms of the care that's provided or the wills that are put in place for them.
Yeah, of course. And it's not just a run-of-the-mill generic tick box.
Yeah,
have you filled this in? Have you filled that in? On to the next one.
Absolutely, that's it. Yeah, it's for us, it's our key to success. It's not about how big we can get or the size of the company you can get. It's more about being able to provide that quality service for our clients, and the rest will follow.
Yeah, no, fantastic. Thank you for that. And over the last sort of 3 or 4 years, what have you seen as your biggest challenge?
I don't know where to start with that. I've seen quite a few, actually. I mean, from going from an employee to an employer.
Yeah.
I've experienced quite a lot, quite fast in the last 3 years, and Natalie, my business partner, would probably also agree. And it's great to be a business owner, but there are many challenges that you face yourself. I mean, you know yourself, when it comes to staffing, premises, all sorts of little things, you know, and at the same time you're trying to do your normal job and make sure that your clients looked after. Spending 20 minutes at a time on a day to a printer company trying to get the printer sorted, or there's a problem with the phones, or there's a problem with the case management system. So we face these problems every day, but actually, look, this is what we do and this is what we enjoy.
Yeah.
And if we didn't have these challenges, then it would just be boring.
No, exactly. So we've spoken about challenges. So what keeps you going? Obviously, you know, you've got your own life, you've got these challenges, you're an employer, you're running your own business. What is it, what keeps you going, enjoying what you're doing?
Oh, I don't know. I think it's my wife and kids, my family for me.
Yeah.
You know, being able to, it's a luxury for me, being able to do something I enjoy doing for work.
Yeah.
And have that flexibility with my family as well. That's what keeps me going. Being able to go into a workspace which we all enjoy working in, we all enjoy going into the office and having a bit of banter with each other, but also working hard.
Yeah.
And being able to have that downtime with my family.
No, I completely, recognise that, and I think it's the same for me. You know, everything I do, I want to provide the quality and the support to our clients, but at the same time, I want to get that extra time with my family, with my wife, with my kids, to enjoy the time that I have at home as well as I do at work.
Yeah, that's it. It's difficult because as well, I mean, you probably do the same, is that you you sometimes tend to think that as a business owner you'll probably do less work.
Yeah.
But actually you end up doing a lot more, and you do make certain sacrifices, but it's worth it.
Yeah.
Yeah.
No. And the last question then. So what is the most rewarding part of your job?
Oh, I think that's for me personally. It's very simple. It's the satisfaction of the clients and the nice reviews. Sometimes you'll see posts where people get a bunch of flowers or something from a client. Actually, I don't need any of that. For me, if they just a thank you, that means the world, and that does mean a lot. And it gives you that boost coming into the office on a Monday and seeing a nice review or some form of appreciation from the clients for the things that you've done.
Yeah.
It's very uplifting. It's very rewarding.
No, I completely agree with you, because I think sometimes you get so involved, don't you, just trying to do the best what you can in the time that you've got, trying to keep everybody happy, but then getting that thank you at the end, knowing actually it's all worthwhile because I have made that difference and I have helped them. And just that little thank you at the end sort of goes, yeah, I've done a good job.
Yeah, definitely, and then that's the difference between having a client for life, or just having them as a single transaction. Because if you do a good job for them and they appreciate the work that you've done, not only will they come back, but their friends will come to you, their family, and so that's the rewarding part for us.
Yeah, no, fantastic. No, thank you for joining us, Christian.
It's been a pleasure. Thank you for having me.
And thank you everybody for watching, and hopefully we'll see you on the next episode of Building Bridges.